What's the difference between legislative findings and declarations versus legislative intent statements? In reading bills in the California legislature, you may encounter findings and declarations or intent statements, or even a combination of the two. Should either be given greater weight by the courts, or are they of equal weight or value? Does it matter if one is codified and the other is uncodified? Or if they're both codified, or if they're both uncodified? So, these and other types of questions could be raised when determining how these types of statements should be viewed, particularly by the judicial branch of state government. I found a recent example for a bill that was introduced in the 2023 California legislative session in January. And in section 1 of the bill, in uncodified language, if the bill were enacted, it contains a number of legislative findings and declarations, 5 of them in particular. And then later on in the bill, in section 2, that would be codified language if this bill were enacted, contains a number of statements of legislative intent, 4 of them to be precise. Now, of course, these two sections could be reversed, where one is where, for example, the intent statements could be uncodified and the findings and declarations could be codified, or they could both be codified, or of course, they could both be uncodified. In either instance, is there a difference? Both are enacted, whether codified or uncodified. Remember, codified means the language appears in one of the 29 codes that contain California's 155,000 plus statutes. Uncodified, it's still enacted into law, but it's not in those 29 codes. This, of course, raises the age-old question of how the court should interpret these two sets of statements. Is one to be given greater weight than the other because one is codified and one is not? Or is there a legal distinction, or at least a judicial-based distinction between statements of legislative intent versus legislative findings and declarations? In terms of codification or not, courts may give equal weight to both of these sections, even though the second section, the 4 legislative intent statements, would be codified. But there are other legal and judicial commentators that see a difference between language being codified versus uncodified, with less weight being given to the uncodified language. Is there a distinction, or should there be one, again, between the findings and declarations versus intent statements? Is there much of a difference or a legal distinction? Is one more valuable than the other? The findings and declarations usually set forth a factual basis or a purpose for the proposed legislation, while intent statements usually obviously set forth the intent of the legislature. Now, courts in this state and at the federal level don't always rely upon either of these types of statements in terms of a statutory interpretation case. So there's definitely some inconsistency in the reliance or lack thereof on either enacted findings and declarations or enacted legislative intent statements. And obviously, to what extent the courts consider or rely upon these types of statements or findings is often debated. Now, there are definitely some judges and legal commentators, again, in debating the merits of codified statutes versus intent or purpose statements. Those folks often believe that there should be a distinction between the enacted provisions of law, the statutes, and then these findings or purpose statements. Others naturally don't distinguish between the statutory provisions and either findings or intent. Some believe that the judiciary should give absolute deference to these types of statements because they're within the lawmaking power of the legislative branch of government, and therefore they're enacted law and they should be considered in the same way other enacted laws are interpreted or given authority to. Again, that's the age old question. My own perspective is that they are often helpful in broad terms. Unfortunately, a lot of litigation is over the actual words found or even not found in a statute. And so findings and declarations, which are more of a factual statement, forming the basis and intent, might be helpful for the proverbial 30,000-foot level view of a statute, but perhaps not so helpful when it comes to a debate or litigation over the actual words of a statute.